Item number 28. Item number 32.
May I pray, Lordship? Lordship, with the consent of the petitioner side, Lordship, I beg to mention item number 35, Lordship. Lordship, in this matter, rejoinder is yet to be filed, Lordship, on behalf of respondent number 6, Lordship. Therefore, Lordship, kindly 3 weeks time may be given, Lordship, to file rejoinder.
But the request of the concept of the respondent, just after 3 weeks.
Deeply obliged.
Lordship, I beg to mention item number 38, Lordship. Lordship, we need some accommodation in this matter. 38, Lordship.
You want adjournment?
Yes, Lordship.
Have you informed the other side?
Lordship, yes, my colleague has informed the other side, Lordship. Nipur guys.
You are for the respondent.
I'm for the appellant, Lordship.
Yeah, the request of the concept of the appellant is this 4 weeks.
Obliged.
May I please, your Lordship? With consent to the other side, Lordship, I beg to mention item number 32. In this case, Lordship, we will file affidavit in opposition. Lordship, kindly grant for
The
its time,
request of
Lordship.
the concept of the respondent. Does this writ petition?
I am for the respect.
4 weeks. Along with the counter.
Okay.
Along with the counter affidavit.
May I please, your Lordship?
Along with the counter affidavit.
May I please, your Lordship? Also, with the consent from the other side, I beg to mention item number 34 for adjournment.
I'm for the petition amendment, consent.
At the request of the concept of the respondent, this matter is adjourned for 4 weeks.
Obliged, Lordship.
Deeply obliged.
Lordship, I humbly pray for listing of a writ appeal on Tuesday, your Lordship. The matter is that your Lordship, the learned single judge had decided in favor of us, but this honorable court has stayed that order of the learned single judgment. So we have some urgency, my.
The division bench is stayed there.
Yes, my lord.
Either affidavit. For petition. Have you filed any IA?
No,
For
my lord.
vacation of the,
No, my lord, we are the respondent, my lord.
you have the respondent.
Yes, my lord. We
You
are
have
praying
to
for
move an
hearing.
application for vacation of the stay or modification of the stay.
Lordship, we are praying for final hearing. It is at the hearing stage, my lord.
Hearing stage, when the stay order was passed.
My lord, it was in 2023, my lord. The exact date I'm
Thursday.
Thursday. Much obliged.
May I please, your Lordship? Lordship, kindly allow this I for listing on tomorrow, Lordship.
Why?
Lordship, similar WA 415 to 2023 dismissed in this honorable court, Lordship. Lordship, I am as the respondent number 1, Lordship. Lordship, the applicant have filed this IA as he was not a party. Obliged.
Yes, may I please, Your Lordship? Lord, on motion matter, Lord, may I pray for listing on Monday, my Lord? Some urgency is there.
Monday, some, we have some difficulty. Tuesday.
My Lord. Obliged, Lordship.
Daily list for orders, item 1.
The issue raised in the present petition is also pending adjudication before the Honorable Supreme Court of India. And The decision is still awaited next after 10 weeks.
What? Deeply.
Item number 2,
I prepared a chart, my lord. Chart. My lord, incorporating the details given by the respondent states in their affidavit.
We have the soft copy of this, soft copy.
Soft, yes, my lord.
So
I'll provide, my lord. I'll provide.
do you have some, any objection regarding this?
No, my lord. As per their affidavit, my lord, the only thing is that, my lord, they will continue to monitor this, that your lordship will kindly observe. Because since it's a policy, in future, my lord, such unauthorized structure should not come out. This is a,
Yeah. Yes. So much. The content. That is the main.
Order dated 31/1/2018 by which
The Honorable Supreme Court in special leave to appeal civil number 8519 public 2006 took cognizance of the news item published in Times of India, Ahmedabad, wherein the issue regarding the encroachments of religious structures in the country has been highlighted. Stop taking cognizance of the same, the Honorable Supreme Court has passed various orders from time to time. And ultimately, on 31st of January 2018, the writ petitions, the special leave petition and another connected writ petitions were transferred appearance on behalf of the respondent number one. Having heard the learned counsel for the applicant, and after going through the contents of the IA, we deem it appropriate to condone the delay of 171 days in filing the present appeal. Hence, the IA number so and so is allowed. The delay of 170 days, the 71 days in filing the present appeal is connected appeal is condoned. Registry is directed to connect the to register the connected appeal and list it before this court after a week.
Lordship. Item number 12,
169 days. 160.
May I please, your lordship? My lord, in terms of the last order of this court, my lord, my lord, the petitioner, my lord, I have served the copy to the standing council
Yes, what
PWD
happened?
13.
What happened last time?
I have already served copy to them, my lord.
Last time this direction was given to you to get the notices served upon the respondent number 13.
My lord, I have served already. I am for
Filed any
PWD.
Have you filed any proof?
My lord, I have.
Where is that?
My lord, we have to file. I have already served, my lord.
Nikhil and counsel appearing for the standing counsel appearing for the PWD has submitted that they have already get the notices of this PIL PIL petition served upon the respondent number 13. They want some time to submit the proof list after a week.
My lord. Deeply obliged.
My lord, can it be, my lord, after 2 weeks, my lord?
2
I
weeks.
will be out of state.
item 13,
May I please, your lordship? I have filed an additional affidavit, your lordship, as per the law.
You are appearing for?
My lord, the department PNRD, Panchayat.
After serving notice upon the respondent number one, I have filed one additional affidavit, your lordship. Because in last order, I was asked to serve that.
Copy दिया था।
Okay.
It will. ये मैंने एप्लीकेशन में आया भी दिया था।
He should read
That's the service will be given, yes.
He's talking about the affidavit of custody service. Yeah. When did the game stand up with the life things step like the steel, like all the different. Exactly to make the approval and send approval before the approval and then. Review to accept. The affidavit is filed on behalf of the. Lab. Regarding service of notice upon the respondent, respondent number one. Taking note of the same. The service upon the respondent number one is deemed to be complete. Is this appeal for admission
And next week, your lordship.
after 10 days?
Obliged.
item 14,
Yes.
May I please, Lordship? This is an application for readmission of income tax appeal, my lord. This application has been filed under Rule 42, under Order
Why-
42, Rule 1.
Why on the last 2 dates, no one is appealing on behalf
My
of
lord,
the.
this appeal was admitted on 8/12/2023. And we were expecting that it will come under the heading of hearing, my lord. My office just missed this, my lord. My apologies for that.
This MC is filed on behalf of the applicant. Yeah, sir. Would you like to make a notice on that? Basically, sir, I will get it. But right now, we have without notice, it's coming. If you pay on that one, within a pay, or pay. And the CGC culture, they will be listed in your. And it is to the appellant. Is for the central government council here?
Mr. SCK, he's the income tax department standing from notice. GST, no, income tax.
No. He's in less.
SC Kyle is a standing counsel, Lordship. No, CGC doesn't deal with the income tax cases, Lord. Otherwise, Central Government Council doesn't deal because they have their own standing counsel there.
Where is Mr. Kyle?
He's in Lex in another court.
Call him. We'll take after some time.
Okay, Lord. Okay.
For a while.
Item 15.
May it please your lordship. My lord, I am audible, my lord. My lord,
Application under section 5, the limitation act. Returnable on so.
my lord,
The notices, the requisites be filed within a period of 1 week for service of notice upon the respondent through registered daily. Yes, next.
Item 16.
my lord,
Yes,
my lord, in item 15, I was appearing on behalf of applicant. Perhaps I was not audible, my lord.
we have already issued notices to the respondents of IA.
My lord, grateful, my lord. The delay is 114 days.
Whatever it may be, we have already issued notices.
I'm grateful, my lord. I'm grateful.
Item 16.
May it please your lordship. This is an application for the request for condoning a delay of 46 days, lordship, in filing of this appeal.
Same order. Yeah, earlier.
Oblige, your lordship.
For admission, item 17.
May I please, Lordship? I am appealing against a impugned order dated 2/4/2024 by WPC number 2089N 498 in a matter of public procurement, where some vital fact and statutory provisions were not considered while delivering the judgment. Despite of those fact and statutory provisions were put on record.
Yes,
I am appealing against the judgment dated 2/4/2024 passed by Honorable Single Judge by WPC number 2089N 498
yes.
of a matter of public procurement, where some vital fact and statutory provisions were not considered while
Which provisions were not considered? If the
that
government has taken a, or the respondents have taken a decision not to procure this, whatever the sprayers or what, sprayer machines, and they, decided to get it, obtained from the GM, through GM, what's wrong in that? How
Yes,
can
sir.
you compel the,
But sir, the provision of getting the view from the finance department is not provision in any procurement act, which I have mentioned on the grounds.
that is their administrative, whatever the into the adjustments and they
That
they
was
can
a-
take the,
That was the interdepartmental view, my lord.
yes.
That
is
view,
your-
whether
What
that,
is your indefeasible right? That once you have applied, so they are required to place your order. What is your right?
because the matter was as per Assam Public Procurement Act and section 26, they have violated section 26, my lord.
Yes,
On the other hand, they have violated rule 24 of the Assam Public Procurement Rule 2020. A copy has been annexed, my lord, at page number 120, 120.
120.
And regarding section 26 of Assam Procurement Act, the annexer is page number 117.
120.
Sir, kindly see first page number 117.
So first we have to see what?
Page number 117, my lord.
117.
Yes. My lord, this is a section 26 cancellation of the procurement process. May I read, my lord? None of the provisions was complied. My lord, may please also see page number 22 annexer A.
Just a
You are the L1 or L2 bidder.
I was the L2 bidder.
Then
my
what right you have? The learned single judge has held if it should go at all, then it should go to L1.
No,
But
no.
the gem is fine. That's the.
Kindly see page number 22, my lord. Annexer A. They have recommended my rate. Height page number 22, annexure A.
Recommended. Recommended. Review committee. सिंगल जज में इसमें कोई सिंगल जज में एक बात सही होगा प्राइस बीट से पहले टेक्निकल टेक्निकली अगर वो आइटम का ओके कोई क्या बट एनीवे मैंने कहा कि जेल से खरीदेगा अच्छा कॉन्फिडेंस आई डोंट थिंक इन्होंने तो देर कर नहीं मैंने मच कोई गवर्नमेंट का What is that instructions to tenders? You have submitted those instructions to tenders.
So it is written in section 37,
Page
page, my lord, 52,
52.
point number 37.
Just a minute.
The acceptance or rejection of bids raised to the director, sorry, a development who does not bind himself to accept the lowest bid order resolve the right to reject fully or partially any or all of the bid without assigning the reason whatsoever thereof.
Deadline submission of which the purchaser may modify the bidding document.
My lord, through this point number 37, they have selected our bid. And I have a case law where it is mentioned that L1 is not entitled to get the work in some cases. May I read, my lord?
Bid committee के recommendation accept करेगा कि नहीं करेगा ये भी आपको ये विषय में taken this guidance and the approval of the public department. Yes.
My lord, I have some case law where it is said that price is not always the sole criteria to select L1. Price is not the sole criteria to select the L1. In as for example, Roanoke International Limited versus IBR Construction Limited and others in Supreme Court.
You just tell me one thing. What is your legal right to have this contract executed? What is your legal right? Show us any law on this. Okay, once they have decided to accept it, to give you an order, then they are bound to give you order. Show us any law on this.
Kindly see page number 22, my lord. They have kindly see page number 22, my lord.
Yes.
It is said, therefore, the relevant person is, therefore, the committee decided to award a supply of battery operated hand sprayer to L2 bidder.
Fine.
They have, this committee has decided.
Then what about this instruction 37, this instruction number 37?
As per 37, instruction number 37, they have rejected the L1 quotation and they have decided to award my quotation.
37, the acceptance or rejection of bids rests with the Director Char Area Development Assam, who does not bind himself to accept the lowest bid and resolve the.
Yes,
right
my
to
lord,
reject
lowest bid.
fully or partially any or all the bids without assigning any reason whatsoever thereof.
Okay, now a question arises whether, despite of I am L2, why my rate was selected.
No, not, maybe your rate was selected, but after taking advice from the finance department, if the director thought it.
Comment, secretary.
Their advice,
They thought it fit that no, it is not bid should not be accepted and the items should be procured by government marketplace. What's wrong in that?
sir, that advice that Sorry Development has taken from the finance department was not as per law actually.
What is the, why as per law?
The observations.
Prohibition from taking any advice from the finance department?
Yes, because this is a public procurement matter in any of, in the Assam Public Procurement Act and rule whatsoever, there is no provision that,
Where is the bar?
there is no provision, my
That's
lord.
another thing. Where is the bar?
There is no provision that they
Until
can
and
ask for
unless there is
any.
a specific bar, they can take advice from the finance department also. Ultimately, it is the finance department who is providing them fund.
But that was not provisional in the Assam Public
Where is
Procurement.
bar, sir? There is no provision, that's right. But where is bar that they can't take any advice from the finance department?
But the finance, may I please give some points regarding the view,
Regarding the,
view of the finance department. They have opined that L1 contract should be awarded to the L1 bidder.
that's right.
But there is a case law of BN Joshi and Sons and Nair Coal Services Limited in the Supreme Court. It is said that it is held that it is not always necessary that a contract be awarded to the lowest tender, and it must be kept in the mind that the employer is the best judge. Therefore, the same ordinarily being within its domain, the High Court jurisdiction in this matter being limited, the court should normally exercise judicial restraint unless illegality or arbitrariness on the part of the employees apparent on the face of the record.
That
Now,
is against you, sir.
now, sir, there is another point. Ronak International Limited versus IBR Constructions. It is point number. It is said like that, sir. It is also necessary to remember that price may not be the sole criteria for awarding a contract. Often, when an evaluation committee of experts is appointed to evaluate offers, the expert committee's special knowledge plays a decisive role in deciding which is the best offer. They have decided.
You just tell me.
Price
what is
offered,
then you are arguing for the this L1.
No, ma'am.
That they.
No. This
Price
is
cannot be a criteria.
because L1 rate. Why they have rejected L1 and choose my rate was
Why they have
reasonable. I am
rejected
just.
L1? Why they have rejected the L1?
Pardon, sir.
Why they have rejected the bid of L1?
Because as per the point number 37, it is written.
That point number 37, so it is applicable to L1 and not L2. Where specifically said one bid or all bids, lowest bid or all bids, he can reject. So if he can reject the lower L1 bid and with the power to have reject all the bids, what's wrong in that? Indicate. This,
My lord, I may be allowed some more time.
what,
Just
for what?
To satisfy you. I may be allowed.
You need more time to apply for the
Only
new tender.
1 week
It's
time.
better you seek some more time to apply for new tender. Why you waste time
No,
in this
no.
litigation here?
I may be allowed, my lord.
Why you are wasting?
Only
your time?
1 week time.
There's nothing in that. You take your own time in applying for some other tender of the public procurement. Government is issuing many tenders. You know it.
This is arbitration, my lord.
Arbitration,
Justification was not done against me, my lord.
so that we'll deal with it. Okay. This intra-court appeal is filed by the petitioner being agreed with the appellant being agreed with the order judgment dated 2/2024 passed by the learned single judge in writ petition number 2089/2023 and writ petition number 498/2023. Stop. The brief facts of the case are that the respondent number, who is the respondent who floated
my
the
lord.
tender?
Director of Surveillance Development.
The respondent number 3 in the the respondent number 3 in the present appeal has floated a tender for procuring spray battery operated hand sprayers wide public notice dated, which was the date.
9/11/2022.
19/10/2022.
9/11/2022.
9/11/2022. Full stop. As many as 7 persons have applied pursuant to the said public notice. And during the course of bid evaluation, financial evaluation of the financial bid, the rate quoted by the by MS Bambani
Balraj.
Babani bracket in bracket Dilip K.R. Das was found to be lowest and he was placed as L1. However, the appellant, the rate quoted by the appellant was found to be L. However, the appellant was placed as L2 as per the rate quoted by it. Full stop. The bid evaluation committee has rejected the bid has rejected the bid of L1 on the ground that the rate quoted by him by it is too low and there is a possibility that there may be compromise in the goods supplied. Full stop. The bid evaluation committee in its meeting, the bid evaluation committee has thereafter decided to place order to the appellant who was L2. Full stop. Later on, the respondent number 3 has cancelled the tender process on the recommendation made by the finance department. In agreed with the same, the appellant has preferred writ petitions before this court which came to be dismissed by the learned single judge wide impugned judgment. Full stop. The learned single judge, while considering the facts of the case as well as the submissions made on behalf of the appellant, has concluded that as per condition number 37 of the bid document, the director is empowered to accept the lowest bid. Is empowered to reject all the bids and therefore, if as per the finance department, as per the advice of the finance department, the tender process has been cancelled, there is no illegality in the same. Stop. The learned single judge has also taken into consideration the fact that the state government has now decided to procure the items through government e-marketplace. And the same is in public interest. Therefore, also no interference is called for. Learned counsel for the appellant has submitted that
Appellant in person.
appellant in, the appellant in person has submitted that in the, that there is no provision under the act which you are referring,
Assam Public Procurement Act 2007.
Assam Public Procurement Act 2017, to seek any advice from the finance department. Stop. And therefore, the director, respondent number 3 has illegally cancelled the tender process as per the advice of the finance department. Full stop. It is true that under the provisions of the Act of 2017, there is no provision for seeking advice of the finance department, but it is also true that there is no bar in seeking advice from the finance department. And if the respondent number 3 has cancelled the tender process as per the advice of the finance department, we don't find any illegality in the same. In view of the above, we don't find any merit in this appeal. The same is therefore dismissed.
I'm so deeply obliged, my lord.
Leftover item 14.
Eight one to Bishay Napa.
Yes, Mr. Kayal.
On inspection, I am appearing, Lordship. He has no objection if matter is restored, Lordship.
Yeah. This his name is
Admission. Readmission. Appeal. This. Appeal admit होने के बाद अगर dismiss होता है तो appeal has to be readmitted.
this miscellaneous cases filed on behalf of the applicant with the prayer for restoration of the ITA appeal, ITA 10/2023, which came to be dismissed.
Order भी गलत है.
प्रेम हो गया नहीं which came to be dismissed in default by this court on which date we have dismissed it?
26/2/2022.
26/2/2022, 24 on account of the parents on behalf of the appellants. Having gone through the appellants, Mr. So-and-so, Mr. So-and-so appearing for the respondents on behalf of CGST has submitted that the department has no objection if the IT appeal number so and so be restored to its original number. So, having gone through the contents of the miscellaneous case, and after hearing the consent of the parties, we deem it appropriate to restore the IT appeal number, ITA number 10/2023 to its original number. just after 2 weeks now. Keep the track of the dates.
I don't.
The MC is disposed of.
Your appeal has not been admitted.
Only substantial question of law has been framed, but a formal order of admission is not there.
It was there on 8/12, my lord.
At 12, we had 8/12, formal order of admission is not there.
Substantial question has already been framed, my lord. Case
Yes, substantial question is framed, a formal order of admission is not there.
That part is
For
omitted.
that reason, it has to be listed again.
Item 18.
But we have heard on this. Yes,
Lordship, appeal prevailed against the order dated Lordship 13/12/2023 passed by the learned single judge Lordship. Impugned order Lordship have a look at page 10 and finding of the novel single judge at page 12 Lordship para 7.
work was executed by you when?
Lordship, it is in the year 2012,
12.
but work was incomplete.
You approached
Lordship-
this court when?
Lordship, work was incomplete. No decision was taken by the authority from 2012 to 2020.
So
And it was withdrawn in the year 2020 and thereafter communicated to him. That is, Lordship, kindly have a look at page 39.
So you waited for up to 2020.
Oh, Lordship, no
25.
decision taken, Lordship. As the authority has taken no decision, he has to wait. And it was communicated in the year 2020.
Actually, I thought they were asking about the petition filed in 2000. So what you were doing up to 2012 to 2020?
Lordship, no decision could be taken by the
So
authority.
you should have approached them. Why you are not deciding by this?
He approached,
When?
but all along, Lordship, from 2012 to 20. But it was
Can't you believe that
withdrawn in the year 2000.
2020, you simply approached them.
Work
then
was withdrawn in the year 2020
regularly
and
approached
thereafter.
them. That can't be. And after, even though if you came to know about 2020, what about why you have approached this court in 2023?
Lordship, that is true. But in the meantime,
That
he
is the
started
truth,
legal.
then it's okay, sir.
Lordship, in the meantime, he started legal notice in the year 2022. And authority also, Lordship acknowledged. Lordship, kindly have a look at page 44.
Yes.
Page 44, kindly have a look.
Yes.
This is the letter issued by the respondent number 4 in the year 2022
Yes.
and thereby asked for the fund and the Lordship due amount was acknowledged.
So they've acknowledged it, they'll.
Lordship,
release
one
the
more
amount.
thing, here is a composite prayer in the writ petition, one for releasing bill amount and another for security amount. Security amount, he cannot claim until and unless work is completed. Work was withdrawn in the year 2020 and thereafter he claimed. So,
So still, since the work was cancelled in 2020,
Lord-
or you have been informed that it was cancelled.
thereafter it was informed. After 2020, it was informed to him.
Then keep approaching them. If a person is not vigilant about his rights for so many years, this court is not supposed to invoke extraordinary jurisdiction for such persons. And the learned single judge has rightly taken into consideration this fact and based on the Supreme Court judgment, nothing else. If you want, withdraw this appeal, will grant you liberty to approach the concerned authority for redressal of grievances and will direct them to consider the same objectively.
Lordship.
After attempting to argue the matter for quite some time, the counsel for the appellant has submitted that he does not want to
he does not want to press this writ appeal, however seeks liberty for the appellant to approach the authorities concerned for redressal of his grievances. Full stop. Dismiss with liberty as laid forth. If the appellant file any representation before the authorities concerned for redressal of a grievances within a period of 2 weeks from today, it is expected that the authorities concerned shall consider and decide the same objectively in accordance with law expeditiously.
Like item 19.
Yes, my lord. My lord, I am the petitioner in person. Am I audible?
Yes, just a minute, hold on.
Okay, sir.
Petitioner in person appearing with the band.
You are an advocate?
Yes, sir.
You are an advocate? Right?
Yes, sir. Yes, sir. I'm enrolled with the Bar Council of India. Yes, sir.
Okay.
Yes.
It's your personal case?
Yes.
You are
This
not,
is my personal case, sir. Yes.
you are not required to come in the ropes.
Sir, actually, I'm out of the state, not carrying this rope along with me. I apologize for that, sir.
There is no adjudication, so you grant the file.
So how you are aggrieved by this order? How you are aggrieved by this order?
Sir, because the learned single judge has failed to consider my interim prayer as well as ignored the principles of natural justice, which I have the right, sir.
Till date, the issue
Yes,
regarding
sir.
maintainability of the writ petition is very much there. Until and unless it is satisfied by you, how the learned single judge can pass an interim order?
Because, sir, I have asked for the interim prayer for
Asking if the interim orders are to be granted, then it's okay.
Sir, because of this 4 week, because the learned single judge has ordered to list the matter after 4 weeks, because, sir, I'm
You can
not
apply
belong.
for listing of the case before the learned single judge. How this appeal?
Next to listing.
Because,
Next
yes,
Wednesday.
may I, sir?
मतलब repetition, hearing the point of.
Sir, I am not able to secure another job because of the termination order or because of the order, because of my writ petition after 4.
Madam, there are so many issues. First of
Yes.
all, regarding maintainability of writ petition, you were engaged by a private entity which doesn't come into purview of state of Article 12.
Sir,
To answer that. And this issue was raised by the counsel for the respondents.
Sir, NHIDCL is a fully, it is a public sector unit fully under the administrative control of the Ministry of Road Transport and Highway. So, sir,
Who have
yes,
engaged? Which authority has engaged you?
I have duly given the examination conducted by NHIDCL itself. I am being recruited through the
39,
agent.
Page
Yes,
39.
I accept that fact,
Page 39, contract of engagement.
sir. But I have the right to invoke
We
my
are glad to, just a minute, ma'am, please. We are glad to give this offer of engagement with our organization, Messrs Pioneer E-Solution Private Limited, in the capacity of young professional for certain period contractual. You were engaged by this Messrs Pioneer E-Solution Private Limited, not by the NHDCL.
Sir, I was deployed at NHIDCL.
However, it may be, they,
NHIDCL only, sir. I represented NHIDCL everywhere in the Assam, wherever I have been. I have
Yes.
signed NHIDCL, sir.
This Pioneer E-Solution Services is rendering services to the NHDCL, and in pursuant to that, they have supplied some manpower to them. How you are employee of this NHDCL?
Sir, I accept the
Treated
fact.
as a-
Sir, I accept this. There is a clause, there is no employer-employee relationship, but sir, that will not override the principles of natural justice. I have been terminated without affording any opportunity to show cause
Ma'am, for
or
that
hear.
reason, you have to satisfy that your employer is coming in the purview of the state. Otherwise, this private entity, Article 226, we cannot exercise Article 226 against the private entity except in a writ of habeas corpus.
Sir, may I, sir, please, sir, can you please, sir, please see the page number 14 of my writ appeal. There is a judgment delivered by the Honorable Supreme Court in the
Yes.
KC Union of India, wherein it was held that contract of service has to be in tune with Articles 14 and 16 of the Constitution of India. If it is to be suggested that one can
That
dismiss.
is, again, that judgment
Yes, sir.
pertains to an employee who was engaged by a private entity or contractual service in the organization of a state.
Sir, this is a contract. This judgment pertains to the contract of service, contractual services. That is
Contractual services.
on my
engaged-
case.
The person was engaged by whom? By the state or a private entity?
Sir, by private entity, but
Where is that? Where is that?
Yes.
Where is that in the facts of the case? You just show us.
The recommendation has been given by the NHIDCL only. And sir, I have also
Can't be treated, you have to satisfy. And your issue regarding the maintainability is very much pending before the learned single judge. Before that, this type of writ appeal can't be entertained.
Sir, there is when there is a
Where is a prayer on your behalf or on behalf of your counsel to stay that of order? Where is that? From this impugned order, there is no prayer for staying that. And if
Sir,
you have not prayed and the learned single judge has not passed any order, what's wrong in that?
Sir, my counsel was duly prayed for the interim relief at the time of the hearing, but it was not considered. It was not even reflected in the order, sir. When it was not reflected, when the order is silent, so it means, sir, it's the refusal of the.
Just a minute.
Sir, I am not, sir, my main grievance is this has caused me irreparable injury because I'm not able to secure any job in the future. Till date, since 19 January, I'm not able to get any job there because of this unsatisfactory performance. I have been working there since 3rd of January 2020, more than 4 years, sir. How come my performance becomes unsatisfactory all of a sudden because of this? Sir, if you please go, I'll also apprise you with the fact, please see the page number 16, para 14. My lord, may I proceed? My lord, may I proceed?
Proceed.
Yeah, my lord, I have filed complaint before the Internal Complaint Committee on 8th of March 2022. Because of the derogatory remarks I have faced from the one of the employee of the NHIDCL itself, Mr. Ranjit Jha. Till date, sir, there is no hearing from the NHIDCL itself. They cannot refrain from the responsibility of fulfilling the.
Ma'am, we have, just a minute, we have already gone through your petition and we are aware about the facts of the case. Please don't repeat those facts. What we are saying, please try to understand. We are not going to entertain this writ appeal since there is no adjudication on merits by the learned single judge and still the matter is pending before the learned single judge. You go and pray for interim relief or whatever you want before the learned single judge. It was adjourned for 4 weeks and now the 4 weeks are likely to be over on 8th of March only. So you go and approach the learned single judge, pray for interim order, and then will, if any adverse order is passed, you can take your available remedy.
Okay, my lord.
So withdraw it.
Okay, I'll withdraw it. I'll withdraw it.
Yeah, the concept of the appellant present in person. I submitted that. She does not want, I submitted that the writ appeal be allowed to be withdrawn with liberty to her to pray for interim relief before the learned single judge in the pending writ petition. Dismissed with liberty as prayed for. Dismissed as withdrawn with liberty as prayed for.
Appearance.
Item 20. Gupta.
May I please, your lordship? Lordship may kindly come to page 439, your lordship. That's the
Mr. Consul,
lordship.
we are only against the cost.
Lordship.
Then it's okay, we'll consider your prayer.
Lordship.
But if you are on merits, then you please be aware, the cost can be enhanced.
No, your lordship, I am essentially, your lordship, concerned with the cost, your lordship, because your lordship, it was not, your lordship, the deliberate on the part of the petitioners, your lordship. In fact, your lordship, the 2 plots of land are, your lordship.
Cost is Take the land. Once you have approached the court and the orders are not in your favor, take the land. You are
Lord.
not supposed to stick on
Lordship,
this.
lordship, they should have, your lordship, brought all these facts to the record. I admit that, your lordship, but that was not an intentional on their part, your lordship. They thought that since these 2 plots of land are different, your lordship, therefore they did not. And essentially this 25,000 cost, your lordship.
He admits that there some facts ought to have been mentioned, have not been mentioned. Since the grievance is directed for the cost.
देखिए, Present that this intra-court appeal is filed on behalf of the appellant being agreed with the order dated 2nd of February 2024, whereby the writ petition filed on behalf of the appellants is dismissed on the ground of concealment of facts, concealment of material facts. The learned single judge, while dismissing the writ petition, has imposed a cost of rupees 25,000 on the appellants. Stop. The net concept for the appellant as submitted. He is not challenging the impugned order on merits, but is only agreeing by the direction passed by the learned single judge of imposing a cost of rupees 25,000 upon the appellants. And council has submitted that the appellants are ought to disclose the material facts before the learned single judge of the learned single judge has submitted that the the fact regarding filing of earlier petition could not be brought into the notice of the learned single judge due to bona fide mistake. And the appellant has no intention to mislead the court. It is also submitted that the appellants are the poor persons and based on the advice of based on the legal advice has referred the writ petition. Learned counsel for the appellant has therefore prayed that the cost imposed by the learned single judge be made easy. Good stop. Learned counsel for appearing for the respondent has opposed the request of the learned counsel for the appellant who made the cost imposed by the learned single judge easy. So, having heard the learned counsel for the parties and after going through the having heard the learned counsel for the parties and particularly taking into consideration the fact that the appellants are poor persons, we deem it appropriate to interfere in the impugned order up to the extent of imposing a cost of rupees 25,000 only, rupees 25,000. Hence, the writ appeal only the cost imposed by resultantly the cost imposed by the learned single judge of rupees 25,000 while impugned judgment is made easy. Stop this. We want to clarify that we are not passing any order on merits and are also not interfering in the impugned order on merits.
Deeply obliged, Your Lordship.
Writ appeal stands disposed of.
Writ appeal stands disposed of.
Item 21.
Lordship, 21 and 22 are identical, Lordship. The matter arises relates to the claim of disability pensions. Also, similar writ petition, Lordship, notice has been issued and impugned order has been issued. Three writ petitions are pending, Lordship. Notice has been issued and the impugned order has been stayed, Lordship.
As well as the influence, yes.
Mostly decided relying on the Dharambir case, Lordship, but Dharambir was on 1982, where the presumption was in favor of them. But now the new cases are dealt with under 2008 rules, Lordship.
And the concept of the petitioner has submitted that the issue raised in this petition is identical to the issue raised in WPC number 9/24, 256/24, and 258/2024, wherein a coordinated bench of this court was wherein the coordinated benches of this court were pleased to issue notices and also passed an interim order. So, in view of the above, issue notice to the respondents, petitioner to take steps for service of the sole respondent by registered post AD on the sole respondents by registered post on the sole respondent in both the appeals by registered. post
Writ petitions, Lordship.
Writ petitions by registered AD within 1 week from today. In the interim, the impugned order dated
In 21, it is Lordship 6/4/23,
6/4/23
passed in OA number 22 of 2019.
and other
Other is Lordship 35/2022, passed in OA number 13 of 2021.
shall remain suspended till the next returnable date. The notice will be returnable within a period of 4 weeks. Connect this writ petition along with writ petitions number 9/24, 256/24, and 258/24.
Deeply obliged.
Item 23.
May I please, your Lordship. Lordship, in this case, I am, my limited privilege honorable court is I am not on merits, but the bank has already taken over the possession of the property.
They have taken over.
Yes, Lordship. The only thing, Lordship, my both the daughters are appearing in their final exams, Lordship.
If they have taken the position, then what
Lordship,
relief now you
actually,
want?
actually,
So
so
you
what
want that
happened?
again, the position be handed over to you.
Until the exams are over, Lordship, because on
We
on
thought
the
that, we thought that the position has not been taken by you, then we could have passed an order that up to 16. They may not take the position, but if once
And
they have
Lordship-
taken the position, we can't restore the entire status quo.
that is, Lordship, the bank has assured the petitioner
That's
that they will,
right,
and Lordship,
When they taken over the position of the,
on the day when the petitioner has given the representation
which day?
on 27/2.
So they have already taken over the position on 27/2/2024.
Yes, in the
Now what?
second half.
We can't do. Suppose if they have not taken over the position till day, we could have restrained them up to 16th of March, but now if they have taken over the position, sorry, can't. Why you approach this court so late?
Actually, Lordship, what happened, the petitioner of his honorable court has approached the bank, and bank have assured the petitioner that till the exams are over, they will not execute on it.
Maybe, yes.
And that was on bona fide.
Mr. Pandit, we are already aware of the, we are aware of the fact, and we were contemplating that we'll protect up to 16th of March or 17th of March, but if they have taken over the position, then we can't help.
Where is your client living now, residing now?
In a neighbor's house. And it is difficult on therefore to appear in the exams from the neighbor's house. That is the only difficulty.
You have not mentioned it.
That they have
No,
already
that is
taken
not
over the
mentioned.
position.
That is not mentioned.
Then withdraw it. Or you want an order on merits?
Canara Bank, is there a standing council of Canara Bank?
Yes, there is a standing council. I have served a copy, Lordship.
Who is he?
Name I exactly don't know, but my clerk has served a copy. And newly appointed.
To whom you have served the copy?
Without any order.
And further, Lordship, we are also ready to pay the cost for the bank has accrued in taking the position.
Yes, the amount is so high, 80 lakhs, 78 lakhs rupees are there, and you are offering rupees 1 lakh per month. कब जाके खत्म होगा वो?
I'm saying not that lordship. The bank has accrued some cost while taking the position. I am
Actually,
ready to.
they are supposed to, if they have incurred some cost in taking the position, they are, that is there very much there, they can recover that. Okay, by this petition, the limited prayer of the petitioner, the petitioner has prayed for a limited prayer that the respondent bank be restrained from taking over the possession of the property in question till 16th of March, so that her two daughters may appear in the metric examination or what?
Metric examination.
Metric examination, which are going to be complete up to 16th of March 2024. Stop. Learned concept of the petitioner has submitted that the bank has already taken over the possession of the property in question on 27/2/2024. Stop. In view of the fact that the bank has already taken over the possession of the property in question, the relief prayed for by the petitioner in this petition to allow her to remain, to occupy the house up to 16th of March 2024 cannot be granted, hence this writ petition is dismissed.
Obliged, lordship.
Item 24.
May I please, your lordship.
Lordship, challenging the single judge order, lordship, on for 19/4/18, lordship. I have preferred this writ appeal, lordship. Honorable single judge, lordship, dismissed my writ petition, lordship, on the ground of maintainability, lordship, and which was also on the basis of on the basis of one order passed by a coordinate bench, lordship.
Yes. If the coordinate bench has already
Lordship,
held that this respondents are not a state.
lordship,
then
but
what's
it
wrong?
is a state, lordship. It is a state, it has fulfilled all the criteria of, I think, Article 12, lordship.
Where is that
NERCOM is a,
judgment? Where is that judgment? Whether that judgment has attained finality or challenge further?
Not challenge for them.
Where is the judgment?
Milord, I don't have a certified copy. I have a printed copy from our High Court website. It's slightly not within the A4 size. Milord.
Fine, we'll see to.
Relevant, wherever the single judge, Milord, has. Bit difficult to read, Milord.
This judgment pertains to which High Court?
Milord, the Itanagar bench, Naharlagun. Justice Indira Shah, she was then passed this judgment after looking at the Supreme Court on Article 12 and held.
Some of the judgment delivered here, putting the.
The challenge in this case, Milord, was that there was a project by the respondent 2 and 3 in Manipur. And the petitioner had a similar grievance. So the learned single judge held that it was not a state within the meaning of the term. Neither did it fulfill the criteria of a state. Thereafter, Milord, in my friend's case, the same arguments were placed and we relied on this judgment, and my learned single judge of this court, Milord, this from the permanent bench, relied on this judgment and also concurred. Now the project is finished. Respondent 5 and 6, unfortunately, I am shown as the counsel for respondent 5 and 6. Accidentally, my clerk has indicated that I am the counsel for 5 and 6. 5 and 6 are private individuals. They are also no longer in service with respondent 2 and 3. 2 and 3, Milord, was a society that was set up. My lordship would recollect perhaps that there was a large-scale insurgency in the state, in the northeastern states. So government was not able to reach out to the poorest of the poor BPL people
So certain projects were set up and places like Senapati district, Karbi Anglong, which was racked with militancy, my lord. The society was recruited and set up certain projects, my lord, with conformity with the village people. In fact, respondent one, Union of India is not a necessary party. Respondent four, my lord, is the Karbi Anglong Autonomous Council. They also may not be a necessary party. And respondent two and three, my lord, we are a society. We don't fall within the criteria of 226. This is an extension of the 226.
So now this project has already been completed.
Completed, finished and wound up, my lord.
And he was engaged only for that
Only
contract.
because there was some disciplinary proceedings also. He had
No,
assaulted someone.
this person was engaged
Only
for
for the
that.
project, my lord, not by the society. person.
If you are engaged for that project and the contract is already, that project is already over.
Lordship, may kindly come to the page number 48 and 46, my nature of appointment, Lordship. 48 and
48.
48. Offer of appointment, Lordship. 48. 48 appointment. Due process of law, Lordship. I was appointed, Lordship.
Please refer to your application person and to your post of surveillance is regarded. Contractual basis. Please note.
Period of 6 months.
Lordship. My service was confirmed, Lordship. Thereafter.
What is the relief you are seeking now? If you succeed in this writ appeal, then you want restoration of your service.
No, Lordship, without following the process, Lordship, I was terminated, Lordship.
What is the relief you are seeking now?
For setting aside the impugned order and for directing the authority to reinstate me, Lordship.
Reinstate you.
And
The project is over.
by regularizing the gap period of services.
If the project is over, where they're going to reinstate you? Where? You were appointed only for that contract, that project.
Lordship.
And probationary period was when he was terminated.
No, Lordship.
He did not complete 1 year.
No, Lordship. I
The
completed 2
contract
years.
was only
Lordship.
for a year. Probationary period was for 6 months. Disciplinary issues were there.
No, he was appointed on this 18th of August 2010.
Milord, which is page 46. Page 46, Milord, of his writ appeal.
46, yes.
Paragraph 1, somewhere in the center.
Your appointment is purely
Contractual and initial contract period may be for 1 year. You will be placed under probation for initial 6 months. Now, this is followed by
Unsuccessful.
4th August 2010. Then 18th August, my lordship will see the letter at page 48, annexure 3.
Yes.
That also says that para 2, my lord. My lordship would
The
allow.
appointment is purely on contract. The initial period of contract will be 1 year. He shall be placed under probation for the 6 months. On successful and satisfactory completion of the probation, many discussion may decide. Yes, what happened thereafter?
Thereafter, my lord, he was terminated for.
On which date?
Terminated, Lordship, in the year 2013, Lordship. On Lordship, 30 January 2013.
Lordship would come to page 52, annexure 6.
Yes.
Office order, my lord. He was given a show cause notice on 10th of September, that says in the first paragraph.
10th of September 2012.
12, you know.
So he has successfully completed that probation period.
Which is fourth August 2010. Then he asked him the question, why didn't you under so-and-so and misbehave with so-and-so? Explanation was forwarded to us by so-and-so. The explanation along with show cause notice was considered in detail and found to be unsatisfactory as such acts as serious misconduct according to the conduct rules of the society under chapter so-and-so and service rules and everything. One of the repeat so-and-so, and then next page, you know, is a complaint by the fellow.
Sir, please satisfy us. You were saying that he was on probation for 6 months. So this 6 months are already over.
Hello, I misunderstood I don't have a clear copy of his writ appeal. I'm borrowing my friends. He had
एक बात तो है कि there is already a judgment that is written there, and then that judgment they will come. उसको rely करते हुए क्या है? दूसरी बात है, the project has already been awarded. How do you think?
But you could turn to page 74 of the writ appeal.
Yes, what do you want to say on this, that the project is already over?
Lordship, but my unpaid salaries and Lordship, my
Unpaid
PF,
salaries,
PF dues are also pending, Lordship.
that you may approach them for that.
That liberty may be given then, Lordship.
You want to withdraw this?
Lordship, with the observation of my learned, fine Lordship. Yes, maybe.
This writ petition is filed by, this inter-court appeal is filed by the appellant, being agreed with the judgment dated 19/4/2018 passed by the learned single judge, whereby the writ petition filed by the petitioner has been dismissed as not maintainable on the ground that the NER CORMP is a registered society and cannot be said to be a state or its instrumentalities or agent, and therefore no relief can be granted to the petitioner. Full stop. During the course of arguments, learned counsel for the respondent has submitted that the appointment of the appellant with the respondent as on which post he was working?
The internal auditor, Lordship. Internal auditor.
Internal auditor was purely on contract basis for the project on which for the project which was undertaken by that NARCOM. Full stop. It is submitted that now the project is over and the respondent number 5 and 6 are also not in the management of the NORCOM. And in such circumstances, apart from the maintainability of the writ petition, no relief can be granted to the appellant. Stop. The appellant has approached this court by way of filing writ petition number 1380/2014, being aggrieved with the action of the NORCOM of terminating his contractual engagement without providing him opportunity of hearing. It is submitted that the services, it was the case of the appellant that the services of the appellant were terminated in violation of the principle of natural justice. Stop. Having taken into consideration the fact that the NERCOM that the project undertook by the NORCOM is already completed and in which the appellant was engaged, we are of the view that no relief of reinstatement as prayed for by the appellant in the writ petition can now be granted. Hence, we are not inclined to interfere in this. Full stop. Learned counsel for the appellant has submitted that his claim regarding PF
Lordship. PF not released, Lordship.
PF is still pending with the NERCOM.
And Lordship,
It's an area.
I am entitled other benefits
PF
also,
deposits
Lordship.
and arrears of salary is still pending with the NERCOM. we taking into consideration the same, we grant liberty to the appellant to approach the NORCOM for redressal of his grievances.
I may point out that he has never raised this grievance earlier.
Grievances, and if any such grievance is raised, then NORCOM shall consider and decide the same strictly in accordance with law.
Deeply obliged.
Obliged, Lordship.
Item 25.
My lord, as per last order, my lord had asked to take instruction whether to refer the matter for arbitration. My lord, I've got clear instruction, it may be referred, my lord. But the single judge judgment has to go, my lord.
Is referred to the arbitration?
My lord. But it was his dispute, it was his dispute he was raised.
Payment release की बारे में वो dispute वही है जिसमें हम लोग कहते हैं इसको इसका release कीजिए and after we obtain the payment disputes since they said कि हमारा कुछ use भी है इसके तो we are trying to petition of law then by the petition they are agreeing So both sides are agreeable, then they'll have to file a joint application. Because without that, then we can appoint an arbitrator from the
Both
panel.
the sides are agreeing. You please file a joint application, then only we can pass an order for appointment of the arbitrator.
My lord.
देखिए, learned concept of the parties are in agreement that both the have submitted both the parties are in agreement that the matter may be referred for arbitration to the arbitrator as per the clause of the agreement.
14.3.
Between them.
Clause 14.3. Clause 14.3 of the agreement.
As per the clause of the agreement executed between them. Let's stop. The parties praised for and granted time to file a joint application.
Appointment of arbitrator.
For appointment of the arbitrator. Time paid for is granted list on
After 15 days.
15 days. Which day? April में date दे दो पहले. List on 3rd of April, sorry, 5th of April. 5th of April.
Oh, sorry.
Item 26.
Yes, please. No, this is a central excise appeal by the department. Lordship, actually, this similar case has been disposed of by the Honorable Court, Lordship. Because our High Court has held in that section 11(2)(b) will be applicable in case of refund against the exemption notification.
Without issuing notices.
Lordship, in that case, notice was issued, but nobody appeared, so this order was passed. Similar issue, one SLP is pending before the Honorable Supreme Court.
SLP is pending.
Lordship. Earlier, this Honorable Court has passed order holding that the SEC are entitled to interest in case of exemption notification.
That's correct, but you want the appeal to be disposed of today itself.
Lordship may, if Lordship or otherwise notice may issue notice. Because they have to give undertaking as part of.
Then it should not have implicated anyone as a respondent.
Lordship.
We have to issue the notices for that.
Lordship.
We'll simply issue notice without.
Lordship.
Similar matters are pending, as already been decided.
When it concept the petitioner has appellant has submitted that. Similar matters have already been decided by, coordinated by the office court. The issue notice to the respondents returnable on so and so. Registered AD order. Registered.
Lordship. Much.
Item 27.
Already up here.
My lord, this matter is also, my lord, relates to, my lord, this is to my lord, which is my lord.
PIL through Moto 3 of 2022.
Yeah, that is why, my lord, my prayer will be, my lord. Matter may be picked along with.
Madam, what do you want to say?
Your Lordship, today actually the principal advocate in the morning informed me that his mother has a sudden heart attack.
Who is appearing on video? Next. Sir. List this petition along with PIL Suo Moto 3 of 2022.
Item 28 and 29.
My lord, may I be permitted to appear virtually in this matter, my lord? 28 and 29.
You are already appearing. You are already appearing, sir.
Yes, my lord, I am seeking your lordship permission to argue.
Okay, fine.
My lord, in this matter, my lord, the issue is of the interpretation of section 16, subsection 4 of the CGST and SGST Act. And my lord, there is a, my lord, the demand.
The matter is already pending before the Honorable Supreme Court.
No, my lord, that is what is pending is, my lord, the constitutional validity of section 16.4. In my matter, my lord, I have not challenged the constitutional validity of section 16.4. I am only on the point of interpretation of law, my lord. Interpretation of section 16, subsection 4. My limited submission is that what section 16.4 limits is
okay, the pleadings are
taking of the.
We have yet to.
The pleadings are all.
We are yet to file our affidavit.
So why you have not filed? We have granted you the time.
Yes, I have some more time. Maybe.
How much time?
For the 2 weeks.
Yes, Mr. Consul. Now the consul for the respondents are seeking some more time to file reply.
My lord, that's fine. My request is till the next month there should not be any further proceeding in this matter. That's all, my lord, I am praying for at the moment.
Come to page 50. They said that they are not challenging. Come to page 50, last paragraph.
15, yeah.
Page 50. Last to issue read in the nature of mandamus and or any other.
Page 50.
Yes, Lord.
Yes.
Last prayer. To issue read or in the nature of mandamus and or any other retributory or order direction that omission of rule 61(6), the rule is unconstitutional, ultra-virus and also being violative of article 279. But if indirectly they are challenging 16(4), that is pending before the Supreme Court.
No, my lord, that is not. How can I indirectly challenge something which I cannot directly challenge? My lord, rule 61(5) is on a different footing altogether. It has got no relationship whatsoever with section 16(4) interpretation.
Mr. Consul, you have prayed here, mandamus or any other appropriate or direction omission of 61(6) rule is unconstitutional, arbitrary and also being violative of article 279A. Then what remains? You have taken this prayer. You have prayed for this.
My lord, let me.
Let them file a reply. Let them file a reply.
Retrospect.
Nikhil, let them file a reply.
But kindly keep it on 20.
Learned Counsel appearing for the respondent number 1 to 4. Seeks some more time to file reply. Seeks some more time to file counter to the writ petition. Time period for is granted. 8th April. Based on 8th of April.
Much.
Great.
Item 30. Item 29.
28 and 29 together. Connected matters.
Item 30 and 31.
With please, your lordship. Lordship, appeal preferred by the state of Assam lordship regarding lordship honorable single bench directive to lordship regularize, provincialize the service of the petitioner lordship in the struck down act lordship. So
Service of
provisionalization of service of the petitioner in the writ petition, Lordship. In the Act was struck down, which was 2011 Act, Lordship. And Honorable Court directed us to, Lordship, provisionalize his service, Lordship, under the 2011 Act, Lordship, which was struck down by this Honorable Court, Lordship, by treating his service as a deemed provincialization, Lordship. And my lord may kindly come to page 282, Lordship. They are findings of
Just a
the-
minute.
And my lord, this matter come various occasion. Last occasion, Lordship says proposes the matter to come in the hearing column. As because the matter was not admitted in the earlier occasion, so today it will come, Lordship.
Admit करके hearing में state का भी appeal.
The pleadings are already complete.
Lordship, Lordship.
Having heard we are dictating the order.
Lordship.
Pleadings are already complete. Having heard the learned counsel for the parties, we deem it appropriate to admit this.
Both the appeals, two appeals.
Admit these appeals. Full stop. Hence, admit no need to issue notice as parties are already represented. This writ appeals for hearing in due course.
Lordship.
Notice has gone.
Lordship.
Notice has been issued to the private respondent.
Oh, he has already appeared. Already appeared.
In both the appeals?
Both there.
And her name.
Interim order is there already.
Yes, sir.
The interim order passed by this court is made absolute till final disposal of the writ petition.
Oblige, Lordship.
Our number accepts notice on behalf of the respondent.
Except pleading.
Notice issued or कोई order नहीं. As I understand, the notice that is issued means that appear करे ना करे तो मतलब.
ठीक है, you do issue notice, accept notice on behalf of this.
The technical requirement is procedure. नहीं तो कल को बोल सकता है कैसे मैंने तो उनको अप्राइज नहीं किया.
Yes, with the situation.
आप बोलेंगे एप्लीकेशन है सेम थिंग मैंने एक बड़ा ग्राउंड में उड़ा दिया रूल में इशू नहीं किया कैसे चलेगा रिकॉर्ड कॉल नहीं किया वी हैव नो ड्यूटी बिफोर कोई ड्यूटी नहीं है हमारे रूल मिसिंग जजमेंट भी आप रूल नहीं करेंगे ऐसे बुलाने से नहीं होगा मोशन में लाओ ये करो ये आपके साथ मैंने खुद बेनिफिशियरी तो इसलिए मुझे याद है ये ना मेरे फेवर में लेकिन 3 साल निकल गया 57 करना 3 साल कम खत्म है हालांकि ये सिचुएशंस
हाँ, लेकिन वो भी है, लेकिन करना चाहिए वो कर सकते हैं। Yes, next.
Item 33.
May I please, your lordship? The respondent are required to file an affidavit. Since 29th September 2022, they have not filed the same.
Who is appearing for the respondent? D. Mehta. Mr. Mehta, standing counsel, Guwahati High Court. Who is appearing on behalf of the Guwahati High Court?
ये तो जज बन गया पहले था। हाँ ये आ गया। तो इसमें मिस्टर टीजे मोहन ने तो each के दोनों में से किसी का नाम दिखा था। टीजे मोहन का है लेकिन उनका नाम नहीं है। टीजे मोहन का
It appears that Mr. T.J. Mahanta is appearing on behalf, T.J. Mahanta learned counsel is appearing on behalf of the Guwahati High Court. However, his name is not reflected in the call list. Full stop. List this matter after 2 weeks while reflecting the name of Mr. T.J. Mahanta as counsel for the respondent. Since that his name is not appearing, therefore he is.
For hearing, item 36.
Thank you.
Some similar petitions have already been decided.
Yes, Lord. 4 rounds.
4 petitions in relation to this very same project.
Same process.
Where are those?
there's an additional affidavit dated 20th.
What's the case with 6 of our affidavits?
It is in the additional affidavit.
No, it is in the main affidavit, the first case, then the subsequent cases are in the additional. It is opposition filed by Joy Binan Long Malay.
Long Kumar Bay.
260. 263, the first. A committee was constituted to look into 386 number of schemes. The committee was constituted by this honorable court lordship. Page 263.
First order is in affidavit filed by respondent number 5,
Yes, lordship.
Long Milia.
Respondent number 9. Sorry, respondent number 5, as well as respondent number 9, 2 respondents.
That is 5th March 2021.
Lord,
Which page?
263. It starts from 265. Order dated 24th August 2017. In the present public interest in the talented water resource department, Government of India has launched the accelerated irrigation benefits program under 12
5-year plan to facilitate irrigation of agriculture for the country, an amount of so and so was sanctioned against 386 schemes.
In a number of proceedings. Yeah, I remember 107 of 2015, and then yes, sir. It's addition of 15.
And 540 page now.
This PIL number 37 of 39, what was that?
It is 2019.
Yes, 37 of 2000.
Yes, that is at page 533.
Yes, Mr.
There is a correction and the first order is at 525.
Already you passed an order in the very same matter.
Lordship, in the additional affidavit, they have stated the PIL are not the similar type of PIL.
Why?
In the previous PIL, it has been stated that they have alleged that the schemes were not completed. And in my PIL, although there is one ground that the schemes have not been completed, additionally, I have already also stated that the schemes are overlapping. There is not existing project components in the scheme, and there is a misrepresentation.
Overlapping, what do you mean by overlapping?
Overlapping in the sense, like the previously what happened, the schemes were already shown 100% utilization was given.
Fine.
Then again, the scheme was restructured and no additional work was done. But the schemes, the money was drawn, sanctioned in the scheme.
So have you filed any criminal complaint regarding?
Yes, I have lodged a complaint.
What happened in that?
Nothing happened, Lordship. I'll take
Nothing
your
happened. What do you mean by nothing happened?
Lordship, I have lodged a complaint before I'll take your Lordship. Annexure 20 of my PIL, page 151. This is the first complaint. May I read, Lordship? This complaint was given to the Chief Engineer, Irrigation Department on 11/6/2015.
Yes.
Complaint against non-observation of wide publicity of calling tender for irrigation scheme under AIBP for the year 2012-13-14 and mismanagement of
What
public money.
happened to those works?
Lordship,
That those works for which you are saying that proper applications have not been, this proper procedure has not been
Followed.
adopted. What happened to those projects?
the projects have been shown as completed. Thereafter, the money has been sanctioned and has already been withdrawn.
When? When?
No, you have not lodged any FIR.
I have lodged.
Where?
I'll take your Lordship to FIP annexure 28 and 29, page 192 of my application. To the Superintendent of Police, Chief Minister, Special Vigilance Cell, Panbari, Guwahati, Assam. Prayer for filing FIR for embezzlement of centrally aided AIBP funds for minor irrigation scheme involving.
So no FIR was registered.
I filed a complaint, but
What happened to that complaint?
nothing happened, Lordship.
Then why you not approach the concerned court under section 156(3)?
I understand that the petitioner have not approached. There is a remedy on that aspect.
Then
But Lordship, that doesn't, Lordship, let me place certain facts before your Lordship. Lordship, before I start, Lordship, I would like to take your Lordship to page number 221 of my application.
What is the relief you want in this case?
Investigation, Lordship.
Do you have already lodged a FIR? Go to the court and ask for investigation, that's all.
Because Lordship, what happened was like, since my complaint, in my FIR, I have named the principal secretary and all the irrigation department people. So
Do you have the copies of the, do you have the copies of the earlier writ petitions?
For the additional affidavit which they have filed on the last date, I don't have that copy, but the previous,
Additional affidavit of what? No.
the respondent number,
pleadings- The pleadings of the earlier PILs.
yes, I have that.
You have that?
Yes, earlier PIL.
Which is that PIL?
The PIL 107 of 15.
Where is that?
Lordship, in the earlier PIL, where there was
Suppliers.
uh,
Suppliers the copy will read. Suppliers.
copy of the earlier PIL, I don't have it right now with me, but
So what is, now what you are referring to?
I'm referring to the order passed by this honorable court.
Just show those copies of the PILs, earlier PILs.
Lordship, in the earlier PIL, they have stated about 386 irrigation schemes. But Lordship, in my PIL, I have specifically mentioned that for the year 2014 and 15, the irrigation were not the subject matter of the earlier PIL. I'll take your Lordship to annexure 1 of my affidavit in opposition.
Read your grounds to the petition.
Lordship.
Read your grounds to the petition.
Grounds. For that, it is obligatory on the part of the respondent to take suitable action on the person involved in making new projects for irrigation scheme at site which has already had previously existing irrigation projects, thereby causing overlapping of the project on the same site to defraud the exchequers. For that,
In support of this.
Yes.
What material you
I
have
have.
placed on record?
I will place Lordship.
What material you have placed, and this second, for the respondent ought to have followed proper guidelines regularly, and which are the relatives of his executive member and his close associates were granted this projects?
Lordship,
Who
actually,
are those?
Lordship, actually, what happened was like, when the projects have to be sanctioned, a detailed project.
That's right. Which of the relatives and close associates of chief executive officer were awarded projects?
Yes, Lordship. I have made a statement. Page number 24. D. In the Borjan composite scheme, which is an overlapping scheme, on 13/12/2013, section release order to contractor bill of 10% in CL number 3. Rabirang Ronghang, the younger brother of the present CEM, has been paid. Again, Lordship,
What is the order of award of contract to him?
page number 66, Lordship. Page number 66, 3, the sanction order. Sanction release order dated 13/12/2013. Borjan composite highest extension of left embutment wall, Shri Rabirang Ronghon, 1 crore 80 lakhs was released. Again, Lordship, page number 86. Serial number 20. 4702 CO, Borjan Composite Scheme, extension of guide bond, including project work, Rabirang Ronghon.
Yes. Okay. This writ petition is filed by the petitioner. The style of PIL with the prayer.
Only one issue would like to highlight. He himself was a contractor for 11 projects and he had some dispute with the official. The official lodged a FIR against him. He came before this honorable court under 480. Public notice in this case regarding the others, we have one merit. But his individual status, locus standi, in this case, we have very specifically stated for his locus. In other cases, it is not the same. They were not contract. He himself is a contractor. He was a part of the whole system. We had some dispute and he wanted to lodge case. Rather, case was registered against him. And that possible can come to case 277. In fact, he wanted to blackmail our engineers.
200 and
270, 279.
this is the order passed by this
Yes,
court.
in 482. Under 482, this is a criminal petition filed under 482 praying for performing of the FIR dated 22/7/2016 lost by the respondent number 2 and the consequent charges. Coming to the third paragraph. The fact leading to the aforesaid police case is that present petitioners are named as accused in the FIR dated 22/7/2016 filed by the Principal Secretary Karbi Anglong Autonomous Council Dipu, wherein allegations has been made that all the accused petitioners are indulging in clandestine activities and in the guise of seeking information under the Right to Information Act and after receiving information under the RT Act about the financial status of certain departments, passed over such information to the extremist outfit. Thereafter, after the extremist outfit used to demand money from the concerned department, putting them under threat. On the basis of the FIR case under the PS case number 2 was raised.
What happened to that FIR?
FIR copy we have not alleged.
No, what happened to that? Those criminal proceedings are
Because
pending or-
extremists were maybe finally lordship, they were discharged at the trial. But here the learned single judge's observations I would like to place. The FIR prima facie discloses a cognizable offence and after completion of the investigation, the charge sheet submitted in the case under the aforesaid section of law.
You yourself is a contractor?
Lordship, as per my instruction, he did not do, he have done one contract work. I'll take your lordship to page number 34 of my affidavit in opposition.
Hey,
Annexure number 3, in reply to the FIR allegation which was against me.
whatever it may be, you are a contractor.
No, lordship, at present,
At present, he is not.
I'll take your lordship to my credentials then. I have to prove my credentials before your lordship. If an allegation of FIR has been leveled upon me,
Forget about this FIR since you have discharged. We are not aware.
I will take your lordship to
Forget
the
about
order.
the FIR. You are a contractor or not?
Yeah, he was a contractor.
Was there now at present what he is doing?
He is an RTI activist, lordship. I'll take your lordship.
Is the,
No,
the
he
this
is
RTI
working-
activist is also a vocation?
No, lordship, I'll take your lordship.
The RTI activist, you are saying like you are a government
is-
job man, you
no,
are what RTI
He
activist
he
is
is
a
working,
vocation.
he's working for people of the state of district of Karbi Anglong. I'll take
So
your
you
lordship.
can very well say you are a social worker.
Yes, a social
But
worker.
what is this
My-
RTI activist?
my-
or is
my
it a
apologies.
vocation?
My apologies. Lordship. He's a social worker. I'll
Really,
take,
really, it seems that you are a RTI activist and it is your profession only.
lordship. I'll take your lordship to my.
Yes, thousands of documents you have placed on record and now you are supposed that this court go into each and every document which you have obtained a copy from this under the RTI And then we go through all this, that what are these documents, and then we pass an order on the basis of these documents. What kind of PIL is this? No proper governance in the PIL. Simply, these irrigation projects are so and so, this meeting copy is there, this meeting copy is there. What do you mean by these meeting copies? Why you have placed on record these meeting copies?
Lordship,
And simply quoting from these whatever the documents you have, and you made here and there allegations, and I have this PIL here. Sir, this can't be the manner in which the PIL can be filed. For what reason you have annexed all these documents?
Lordship,
How this court is concerned with the minutes of the meeting of the NLCPR held on so and so, you have placed this meeting minutes. Why?
I understand, Lordship. Lordship, I
You
was
understand,
recent.
sir?
Lordship,
This
I
can't be
was
the-
Lordship, I was recently being engaged in this matter. So, Lordship, I would like to place certain facts about from the affidavit in opposition, Lordship. Yes, right. And with
Sir,
regards
the
to
issue has been dealt with by this court in various other writ petitions, and proper orders have already been passed. We don't find any other order to be passed. We are in agreement with that. And so far as regarding your complaint in concern, you take appropriate action in accordance with law.
Lordship,
In every case, this court can give CBI investigation be conducted. You make up your own mind. We'll hear you at 2. But I'm not going to entertain this.
Lordship, I pray for some time, at least to contact at next week, any date, Lordship may fix the matter.
Wednesday,
Any date.
at the request of the council for the petitioner.
Deeply objective.
There's this petition on Wednesday. Wednesday did the rest on so and so.
Much okay.
For hearing, item 37.
কোনটো আছিলে 27 টো নেকি? My lord, may I kindly have a look at order dated 8/5/23, my lord. The report of the inquiry conducted, as a lordship's got it, in pursuance of the direction given by this court on 27/2/23, has been produced by Mr. N.J. Khatonier, that is Standing Council Education Department, for respondents number 226 in seal envelope, which was opened and perused. The conclusion in the report is that appellant Mumtaz Begum was appointed at 2806 in Akabasti ME School as 6th teacher and was upgraded to the post of 5th assistant teacher of the same school on 8/7/11. Certain other conclusions are drawn in this report, which is taken on record. So, my lord, bone of contention is whether I was initially appointed on 2/8/2008, 2006 or not. And this is followed by a report, my lord. And at the report, the last para of the report, from the above facts and circumstances, it reveals that petitioner Mumtaz Begum was appointed on 2806 in Akabasti ME School as the 6th teacher and was upgraded to the post of his assistant teacher of the school on 8/7/2011. During provincialization as per Act of 2011 as amended in 2012, in the provincialization order issued against Akabasti ME School in the year 2013,
name of the petitioner was missing and one post was shown as vacant. The petitioner had claimed that due to inadvertent mistake, her date of joining was taken to be 8/7/11, but she was appointed on 2806 as sixth teacher and thereafter she joined on the as the fifth teacher on 8/7/2011. Thereafter, the service of the petitioner was provincialized on 22/10/2013 upon correction of her date of joining. Thereafter, petitioner Mumtaz Begum received arrears salary in pursuance of the provincialization order with effect from 1/1/13. So by order dated 27/2/23, my lord, this inquiry was directed. Now the inquiry report is in our favor, my lord. And the inquiry was conducted by a committee envisaged in the rules. I apply for my interest. Okay, headmaster to Morata ne do.
Negative mind was there. There is no relief for the petitioner. Only the respondent number seven's appointment has been helped. Petitioner. She really can. What is there? नहीं वो तो उन्होंने कहा कि really conclude the conclusion by giving listen, it should be followed by manner. It is also very. It has to set aside and some that loan cost for a permanent percentage. School was provincial, but it no matter some post provincial. Mr. Majumdar, what is the method of provincializing? Is the school provincialized or some post in a
Post.
Services.
Not the school.
Under the 2011, it was the posts which got printed.
So this observation that the school was provincialized may not be entirely correct.
That is how it is usually termed by everybody, that the school was provincial, otherwise the posts are provincial.
School gets grant, that is a different aspect. No, yeah, no? Actually, my lord, the headmaster of the school died. बहुत स्क्रूटिनी होने की केस होता है राउंड ऑफ स्क्रूटिनी हाँ एम्प्लॉय फोटो भी करना है आगे होता है बहुत सारे पहले का सबसे पहले
Ultimately, this respondent number 7 was appointed on what post?
assistant teacher when the school was not provincialized at the venture stage on 2/8/2006. When she was appointed, she was the sixth teacher. On 4/7/2011, my lord, the headmaster of the school died while in service. As a result, my lord, everybody stepped up. So respondent number 7 climbed from 6th to 5th. That is how her services could be provincialized. There was a detailed inquiry by the head to head consultant. 8/7/11. This was 8/7 is the date of joining as visa, not date of Date of joining the 5th, actually, not school. He was never appointed. He is appointed to the junior. So she could not have her services could not have been paid. She is not saying that much on me. I believe to be. That will not be.
Copy of the writ petition is there, along with the.
Yes, my lord.
Which page, prayer portion, which page?
Yes, page number 61. 61, no? Huh? Huh? Sorry, page 66, 5. Writ in the nature of mandamus be not issued directing official respondents not to give effect to this order dated 7/11/11 cancelling the appointment of so-and-so by stopping all her present and future financial and other consequential benefit from her LS service at Akabos TMA school. Writ of or in the nature of mandamus not be not issued directing initiation of appropriate criminal and civil proceeding against respondent number 7 and other responsible for illegal withdrawal of the salary she received. A writ of or in the nature of mandamus be not issued directing official respondents to initiate immediate steps to fill up the vacant post of assistant teacher at Akabasti Middle School in accordance with law. Neither here nor there, my lord. Her claim was, my lord, that she is eligible, she can apply that much. Or in 2014, whereas I was appointed in 2006.
Her appointment is of 2004.
She was never appointed, my lord.
She is in.
She is only claiming a right of appointment. And at her instance, my lord, my appointment has been set aside.
Admitted. Court may inquire the before that. Nobody has assailed that. The court will have to accept it. Whole condemned the basis of the judgment. Where did you see the inquiry report? Is it?
Yes, inquiry report, my lord, a copy was given to us after it was handed over to the honorable court. I think in the second file it is there.
Well, actually, second file. Inquiry report, date of the inquiry report?
Yes, my lord, this is dated. It was produced before this honorable court on 27, no. 8/5/2023, the report was placed before this honorable court, my lord. And copy was given to us. It doesn't bear any date, no? No. Report to the I think from findings portion, we can read, my lord, at very first page of the report.
Just
It will report date 9. Signature to date 9. I think there is an order of 24/7/23, my lord, whereby this honorable court directed that in a separate file the report be placed.
Order to second part item. Where is it? Just. Half the or 27/2023.
Hmm? Actually, তো পড়লে হয়ে যায় from SMC পর্যন্ত। কেন নম্বর আছে? এখন নাই রিপোর্ট মোটা হলো Sir. These findings are like. The entire report is based on the audio of this court and it has received this. Who is appearing with the private respondent here in the? Actually, my lord, earlier they were contesting the case very vigorously. But after the report is submitted, my lord, they have lost this team.
Mr. R. Sharma.
No, my lord, Mr. Ganguly appeared.
Respondent number 7, here we have R. Majumdar.
He is representing the government respondents.
R. Sharma, advocate for respondent number 7.
7 is my lord in Ritapil is my lord headmaster of this.
Headmaster of the.
Not the private.
Private
Now,
respondent.
in writ appeal, my lord,
Private respondent is
One.
1.
yes.
Raise notice to the.
No, appeal বলছে। Oh.
One has appeared in this appeal.
Yes, yes, my lord, several dates, my lord. This matter was heard on, in fact, my lord, after the report was placed, this honorable court is about to pass an order, then they.
A. Ganguly.
Huh.
On order dated 8/5/2023, a report was given to the learned counsel for the private respondent.
Yes.
On 8/5/2023. There's another.
So now what do you want to say?
No, the report says that he was working at the relevant point of time. We had provincialized his services. It was only on the instance of the writ petitioner that this honorable court interfered. Our stand still remains.
So in view of the report now, we have nothing to say.
Even previous to the report, we had actually provincialized the
Our
appellant.
services
We had provincialized from the department
in 2013 itself.
when a correction was made to the date of entry.
Okay, this intercourt appeal is filed by the appellant. Being agreed with the order dated 11/1/2019, passed by the learned single judge in writ petition number 2354 of 2014, whereby the writ petition filed on behalf of the respondent number one. The respondent number one herein has been allowed, and the appointment of the respondent number seven as assistant teacher in Akka Basti ME school was cancelled. Further direction is also issued by the learned single judge to the respondent authorities, more specifically to the Director Elementary Education, to examine whether withdrawal of rupees 1.52 lakh by the respondent number seven was in accordance with law, and if not, to initiate recovery proceedings. It is further directed by the learned single judge that the resultant vacancy on discontinuation of service of respondent number seven may be filled up by a duly conducted recruitment process by giving the respondent number one an opportunity to participate if found to be eligible and qualified. Full stop. Para. The issue raised by the respondent number one in the writ petition was regarding the appointment of the respondent appellant as assistant teacher, wide order dated 17/11/2011. Full stop. This court, the learned single judge has concluded that her appointment on the post of assistant teacher was illegal. Hence, the same was cancelled by the impugned judgment. During the course of hearing of this appeal, this court, a coordinate bench of this court, by the order dated 27/2/2023, has ordered an inquiry into the allegations pertaining to the irregularities and illegalities in the provincialization of the appellant under section 13 in bracket 10 and 13 bracket 11 of the Assam Education in bracket provincialization of service of teachers and reorganization of educational institutions bracket close Act 2017. Full stop. As per the direction given by this court, the inquiry was conducted by the Director Elementary Education, and the report of the same was placed before this court on 9/6/2023. Full stop. The concluding part of the inquiry report reads as under.
Thank you, please.
is quoted here and the read as undertaking is quoted here and there. This red to red. Red to red. Stop. As in the inquiry conducted as per the directions given by this court, it is concluded that the appellant was appointed as assistant teacher in the Akka Basti ME school on 2/8/2006. And
There is no irregularity in, and there is no irregularity in my appointment.
and there is no irregularity in her appointment.
This report has been challenged.
Yeah, there is no irregularity in the appointment. We are of the view that the learned single judge, we are of the view that the impugned order passed by the learned single judge cannot be sustained. It is also to be noticed that the findings of the inquiry report is not under challenged either by the respondent number 1 or the other respondents. Full stop. In view of the above, the impugned order dated 11/1/2000, in view of the above, this appeal is allowed and the impugned order dated 11/1/2019 is set aside. Deep level. The respondent number 7 we are putting slash writ appeal. Writ petition.
No, no, writ appeal.
Acha, writ appeal, yes, writ appeal. Leave it, mark.
तो एक ही रह गया.
Item 39.
What was the period of settlement here?
My lord,
Yes.
31st,
31st of March, my lord, this month.
It will expire 31st of March.
new tender has been called on, my lord, and he has also participated. I have also participated.
What remains then? You will close this?
Who is appearing for the private response?
I am.
Then what remains now with the new tender is
No,
already.
I am not on that, my lord. It's true, my lord, nothing is remaining. I think it's that, my lord, the ground for every, my lord, that is not, my lord, subject, my lord. This is the fact, my lord, the
Ground of?
ground of achievement. Because the learned single judge, my lord, there has not committed any illegality while deciding the case, because the tender paper has to be submitted in two modes, my lord. One is the online and another is, my lord, absent. So as per the tender terms and condition 25, tender will be accepted on the basis of the online. So if document anything is left in the online, well, he cannot claim that I have submitted it subsequently. Well,
So
that
that
one
can't be
that-
cured. That
Yeah.
can't be cured by filing a hard copy of.
Hard copy, my lord. So regarding the terms and condition, my lord, the clause four of the, my lord, the application condition and the terms and condition,
We
the, my
agree,
lord, revenue clearance certificate has to be.
we are in agreement with you. But since this period is over, is going to over on 31st of March.
Tender also called, my
My
lord.
lord, I have.
And both of you have participated in
Yes,
that.
my lord.
investment.
It is true, my lord, but thing is that he enjoyed the entire period, my lord, even he was.
No,
not
that's his
recommended-
fate. That's his fate, sir.
But the, as per the, my lord, the lot.
That's the destiny. You have to believe sometimes in destiny also.
But that should be ended. My prayer is, my lord, this should be ended. His property, he is holding the, my lord, the ferry service
Today itself.
today. My lord.
Sir, please.
My lord, otherwise, my
If
lord,
he is going to-
my lord,
He is
otherwise,
going to operate by 31st of March, what difference?
my lord, because my lord, although the my lord, tender was stopped, but the another 2 months, my lord, from April and May, that will be when a short period that will be operated. If it is continuing, my lord, he will be allowed to do the for the same illegal thing. Because when the Tata Cinema case is very specific, that the my lord, nothing can be, my lord, improved in the subsequent. So this is my fact. My lord.
Temporary, my lord, temporary period I am having 31st March, my period of work. He participated, I participated. That is, my lord, temporary, my lord, not permanent.
Mr. Council, now please leave it.
Lucas said the, my lord, should-
Leave it, leave it.
My lord, Lucas said the, at least, my lord.
Hmm?
Is Lucas Sendi must be closed. What Lucas Sendi, he is not recommended, my lord. Entire period will be illegally he entered. Let the, my lord, government decided.
Now no time, my lord, tender has come out. Tender has been.
Okay,
closed.
sir, we are agreeing with you, but we are not passing any order.
My lord, the judicial review, my lord, the power of the court, my lord, it is already been, my lord, decided.
But
by the Supreme Court.
ultimately,
Very
simply,
limited, my lord.
simply for the sake of
Then,
to satisfy ego of one of the party,
my lord,
this is nothing but satisfying ego.
not ego, my lord. I am not an ego, but I am illegal because, my lord, in spite of, my lord, winning the case in the first legal ways, I am not been given the, my lord.
That's the
This is the thing, my lord.
If the court has
The
passed the
legally-
interim order, if the court has passed the interim order,
Page
we should have
149.
given an application for vacation of that interim order, then the.
No, my lord, the fact is that the case.
And
Yes, not
9/11/2023 is the order.
There was a case date, my lord, on 9/1. My lord,
So
by
it
which
is in relation to this two ferries or one ferry service?
Two ferry, my lord.
Two.
Yeah, he's operating both these
Two
two.
ferry.
Okay.
His name was not
This
recommended, my lord.
writ appeal is filed.
Recommended.
This,
Not
the intra-court appeal is preferred on behalf of the appellant, being agreed with the judgment dated 9/11/2023, passed by the learned single judge, whereby, while deciding 4 writ petitions, the learned single judge has allowed the writ petitions, has dismissed the writ petition number 305/2023, 835/2023, 1606/2023. However,
Referred by the appellate.
referred by the appellant, however, has allowed the writ petition number 8323/2022 as disposed of the writ petition number 8323/2022 preferred by the respondent number. Respondent number 5 herein.
8323 of 2023.
Herein. With the observation that the tendering authority is at liberty to proceed and bring the process of settlement in respect of 2 ferry services, that is Jatinga ferry service and Rajnagar ferry service, for the remaining period to the logical conclusion within an outer limit of 2 weeks. Full stop.
Is the interim order as a result of appellant.
It is noticed that the division bench, coordinate bench of this court, while issuing the notices to the respondents,
Order dated 13/11.
this, and coordinate bench of this court, or by order dated 30th of November 2023, has directed the parties to maintain status quo. And the said status quo order is still in currency. Full stop.
On the strength of
As per the said, on the strength of that said status quo order, the appellant is operating the two ferry services in question till date. Full stop. It is informed that the contract for operating the above referred to ferry services is going to be expired on 31st of March 2023. 24. Full stop.
they have floated new tender for the next.
It is also informed that a new tender for
Settlement.
awarding the services for issuing license to operate the above two referred ferry services has already been floated, in which the appellant as well as the respondent number 5 has also participated. Full stop. In view of the above facts and circumstances of the case, particularly that the term of the contract of the appellant is going to expire on 31st of March 2024, and the new tender has already been floated, wherein the appellant as well as the respondent number 1 has also participated.
Number 5.
Respondent number 5 has also participated. We are not inclined to interfere in this.
Conclude the tender process, right? That is first. No extension be granted.
We are,
I have
what
deposited
we
my
have written-
till 31st March, my lord, the
What-
contract period I have deposited.
Just what we. We are not interfering with the impugned order passed by this court. However, it is made clear that the respondent authorities, the government authorities are government authorities required to complete the process, tender process pursuant to the.
What is the date of the NIT?
NIT dated, my lord, NIT, the lordship, I have given the second copy, my lord.
Okay, you just show us. date,
Yes, yes, my lord.
Inform the date.
Not legible. 7
give
to
us.
24. In the exhibit, 7 to 24, my lord.
7/2/24 by positively by 31st of March 2024. And with the further direction that no further extension will be granted to the appellant after 31st of March 2024.
After 31st of March, till the settlement of the new price service, the department.
That is up to you. That is not required.
You are not going to extend him, whatever you want, you do it.